Topic of the day on UBC. Was brought to you by
You can now get all the Chibuzi out with MTN voice bundles. Call all networks. Kubei Dondolo. Buy a 25-minute voice bundle for only 1,000. Or buy any daily voice bundle of your choice. Dial *100*21# and select daily or use the My MTN app. When we talk together, we are unstoppable.
Juko.
Yo.
What you check the shopping, man. What's your secret?
Uganda, haven't you heard of the Parish development model PDM?
Yes, I did, but I thought it was just a talk.
No, Sebatia. It is real. I and a few friends together formed a circle, accessed money from the PDM, invested in a portrait project, and now things are moving.
Juko. I thought I was one of your friends.
You are.
But you left me behind.
I didn't leave you in poverty. What you do, just visit your LC2 chairperson and your parish chief and start the process of economic transformation. Just like that. The Parish development model is an initiative from the government of Uganda through the Ministry of Local Government designed to transform all lives of Ugandans for the better. PDM, my parish, my development, my life.
We're going to be talking about farming, but it's not me that's going to do that.
My name is Hava K. Luanga.
My name is Larry Charles K.
Let's go!
Mixed farm is a type of farming that involves growing crops and raising livestock. This is the spice garden and for the vegetables.
My first favorite spice has to be black pepper.
What's black pepper in Uganda?
Kamulali or mudagavu.
What? We're going to talk about the sechunga. We're going to see how big it is, as big as Larry's head. And then we're going to talk about the mangada. So we're going to get there. We have still so many farms to visit. And I would like to hear from you. This is the Little Farmer Show, and we are bringing coolness back to farming. See you!
Ghetto structure okusoka ffe twali twepima nga ghetto structure tenabeerawo bali batugoba nga bintu si byakubeera nga tusobola okumiitinga mu mwali temusobola na kutumiitinga batulaga bagenda tulondesa obukulembeze ne batulaga nti tulina okweteekateeka ne batulaga nti mu bayamba mulina okubeera ne sako. Era essaawa zino eno n'akasente tukayina mwe kali mu ofiisi tukakozesa ba beneficiaries abantu ab'omu ghetto wansi. Tuyanziza nnyo His Excellency the President of Uganda, Brigadier General Damulira, Major Emma Kuteesa, House Controller, anti-ghetto, tumuyita anti-ghetto. Structure kati mulimu nze nagufuula mulimu office eno ghetto structure mulimu kati gwenkola sikyalina kyenkola kyonna. Banaye ba ghetto youth mwenna bakubiriza ghetto structure yazze n'emikono ebiri ebeere ng'etuyambako oba ng'etujjayo yonna gye tuli ng'etusupportinga mu buli kimu. Veeyo akasente mwe kali mu office ak'okwekulaakulanya mutukire office ensonga zammwe zonna zigenda kukolebwako.
Our program of poverty eradication is a must. We want everybody to be involved.
Through the parish development model, Ugandans are starting small but impactful projects to improve their livelihoods.
When we give 1 million, we know it's not enough to do many things, but it's a starting point.
I'm a PDM beneficiary, a farmer Your Excellency, I was given 1 million Uganda shillings from Kobil Kawo PDM Sako. Your Excellency, I got 20 bunches from my small piece of land sold, got 400,000, put in the PDM farm, Your Excellency, in the PDM money, Your Excellency, I bought a cow of 1,400,000.
In 1 year, 100 families in the parish get. In 5 years, 500 families would have got.
We were the first people to receive money from Nakapriprit. I received $1 million. I rented 4 acres of land and I was able to harvest 14 bags.
So really this 1 million is enabling somebody to start something. Yes, and we don't want to give too much money to one person because we have got very many people to cover.
The parish development model empowers the people, focusing on lifting up the masses and creating opportunities that ensure prosperity for all. This message is brought to you by the Ministry of ICT and National Guidance.
Step into a world of excellence, comfort and pride with Royal Foam Furniture, crafted to perfection right here in Uganda. We bring you state-of-the-art living room furniture and bedding products at affordable prices. Our wide variety of mattresses include orthopedic, pillow top, spring mattresses suitable for institutions like hotels and many others for home comfort. With every piece telling a story of royal excellence, our products are built with the highest quality materials made to last. Experience royalty with Royal Foam Furniture, proudly made in Uganda, so buy Uganda and build Uganda. Visit our showrooms at Ginger Road, Chambogo Junction, Bukoto Chisasi Road, and on Victoria Mall, Entebbe, on the first floor.
Njagala okwebaza olw'enteekateeka eno gavumenti gye yatondawo ey'okulaba nga omuntu wa wansi, omuntu omuwejjero wa ghetto afiibwako. Nti nga ghettos eriyo embeera eyaliwo nga si nnungi. Okugereza ddala mu nteekateeka eno nga tennajja abaana.
Live from UBC Studios in Kampala. This is Good Morning Uganda Extra.
Good morning and welcome to the Extra. Robert Chirabo Nyonyitono. Thanking you so much for being with us from 6:30 till now with the extension of Good Morning Uganda, which is Good Morning Uganda Extra. Now, I usually have a guest or guests with whom we discuss issues of national concern. And today we are going to be handling something very, very sensitive, yet very many Ugandans are not aware of it, or if they are aware of it, they have not benefited from the alternatives it offers you. And that is the bail process, its application and refund. Now, when you talk about bail, many people have heard of bail, have applied for bail, but when it comes to how you apply for it, that is a very big challenge. And the worst is how you get that refund. I must tell you, very many Ugandans in this country that have gone through the judicial process and have given money for bail, as by the law, don't get the refund. Is it a problem of the judiciary? Is it ignorancy? This very year, we saw something that went viral on social media of a young man who insisted he wanted his money. And the truth is, he got the money. Now, join me, welcome Her Worship, Lord Her Worship Zulaika Nanteza, who is the Acting Registrar, Alternative Dispute Resolutions. That is in the judiciary. She's here with us to discuss this topic. Good morning, Your Worship, and thank you for coming.
Good morning to you, sir. Good morning, our viewers and listeners. Nanteza Zulaika is my name.
As introduced, I'm a deputy registrar, but in the rank of an acting registrar in charge of the ADR registry. ADR means Alternative Dispute Resolution. The judiciary has taken significant strides to ensure that we promote ADR among people that have filed cases in court as one of the best modes of resolving disputes. So, by the powers of the Lord and by appointment of the Chief Justice, I am in charge of that registry. I would also want to use this opportunity to inform you that we are going to have a conference on ADR next week on Friday and Saturday. It is called the CFOC conference. This is a conference that is going to be at the national and international level. We have guests from within and from outside Uganda. They are coming to sit and brainstorm on how best we can implement ADR, alternative dispute resolution mechanisms, to support the litigating parties, to have justice in time, to receive the quality of justice that they need, but also to help them resolve disputes amicably and peacefully. We shall at an opportune time be coming back on TV and radio to let the public know what the conference is all going to be about. But I didn't want to miss this opportunity since I know that many people out there are listening and viewing this program, so I wanted to take advantage of the same. Thank you very much.
Well, you're most welcome to the show, and anytime from now, I'm also expecting her worship, Gladys Kamasanyu. She'll be joining us anytime from now. So if she comes on set, yes, we are expecting her. Now, to begin with, when we talk about bail, help the Ugandan or our viewer understand what is bail.
Thank you very much. Bail is a process of court. I call it a process because it is one of those stages in criminal litigation that is undertaken at a level when an accused person is either charged or arraigned before court. I'm using those two words interchangeably because they are the same words, but they mean different things at a different level. When you are charged before court, it means you have been brought before a magistrate grade 1 or a chief magistrate or a magistrate grade 2. And arraignment means you have been produced before a judge in the High Court. So it is the same thing, but used differently because of the level where you have been taken. So when you appear before a magistrate's court and you are charged with an offense, you have a right to apply for bail. When you apply for bail, the judicial officer should listen to you, listen to your submissions, or the submissions given by your advocate, and then make a ruling on the same. It is your right to apply for bail, but the judicial officer reserves the right to either grant you or not grant you bail. When they grant you bail, they'll give you reasons why they think you deserve to be granted bail. But also when bail is denied, the judicial officer must let you know the reasons why bail has been denied to you. For instance, if you are brought sureties in court and the judicial officer has found them not to be fit, they will not grant bail and they will give you a reason as to why they have found your sureties not fit to stand for you. In the bail process, there are 3 parties involved: the accused person, the people coming to stand for the accused, and the court. The state attorney is also in that process because the state attorney represents the government of Uganda. When a person is charged before the courts of law, they can have a private lawyer to represent them, but the state attorney usually represents the state, and therefore they represent the complainant's interest. So when you lodge your bail application before court, if the state attorney believes on behalf of the state and the prosecution that you should not be granted bail, they should submit or give those reasons before court, so the court has an option to weigh between the reasons submitted or grounds submitted by the applicant and the reasons for not granting that have been submitted by the prosecution, which is the DPP, to either grant bail or not grant bail. I want to call people out there to understand that when you're produced before court, the judicial officer will not just grant you automatically. You must apply for bail. It is your duty to move court to listen to your submissions or the submissions of your advocate. So when you come to court, please put up your hand, especially after charges have been read to you and you have denied them. So the moment that the offense is read to you, for instance, Nantes Azulaika, you are charged with the assault, God forbid, and then I say, no, it is not true. I did not beat Mr. So-and-so. I did not beat Mrs. So-and-so. Then after that proceeding is done, then you raise your hand and apply for bail. So usually people come to court and they don't apply for bail, and the public out there is busy condemning the judiciary and the judicial officer for not granting bail, not knowing that the person did not exercise their rights when they were before the trial court. So make sure you apply for bail, and the judicial officer has a duty to listen to your submissions and see whether to grant bail or not to grant bail. There are so many factors that we consider while granting or not granting bail.
Maybe before we go to the granting, one that I want to get clear from you, the judicial officer, what is bail itself? Because these may seem common, but there's someone asking, what is bail that they're talking about? Two, you said the judicial officer has the discretion. Now, for me, I know bail is a constitutional right. I can say, when they put me before the judge, I'll apply for bail. It's a constitutional right. But if it is a right, then I hear the judge. It is, I want to use in layman's language, that it is upon the judge to decide if they give me bail or not. But at the back of our mind now, many of us say, no, bail is a constitutional right. Well, why are they denying him bail? I want you to have how you make me understand those two better.
Okay, my beginning statement was defining bail. I stated that bail is a process of court where an accused person who has been charged before court or arraigned before the High Court seeks that the judicial officer grants them bail or makes an application that they be granted bail. That is how we define bail. So it is a process of court where you apply to be allowed to go home and stand trial while you are coming from home.
That is what I wanted.
Yes, while you're coming from home. Because so many people ask...
So it is giving you temporary freedom.
Exactly. I don't want to say temporary freedom as such.
Because if I've come on, don't want to go, on what?
On handcuffs.
On handcuffs, you know, I mix them with cufflinks. On handcuffs. If I've come on handcuffs, then as I'm being arraigned, they remove the handcuffs. I'm from the University of Understanding, their van. Now, if the judicial officer says, I've given you temporary freedom, but you report at such a time, I love calling it temporary freedom, because you're not going back to the cells, you're going home, but of course, definitely, prosecution is continuing.
Okay, for purposes of our listeners, for them to be able to understand, it's okay, temporary freedom like you have defined it, because someone has already an offense before court, but they are being allowed to go home and be coming back to court on a date that the judicial officer will give them to stand trial for the offense with which they are charged. So you're going back home, but it doesn't mean that the case has ended. So many times we find people who have been denied bail, and there's a lot of public noise. Then there are so many people who have been granted bail. Again, there is a lot of noise that is done. I'm using the word noise in a respectable way, not in a way of undermining people, but I mean as in people talking about the fact that someone has been denied bail or granted bail. The judicial officer is given this power. It is like you, when you are in charge of this station, you have powers that are entrusted with you, isn't it? So even us as judicial officers, we have powers that are entrusted with us, but we don't have to abuse them. That is why you see, even in the Constitution says, bail is a right. I should not just grant you bail automatically. There are cases where bail is deserving, and there are those cases where bail is not deserving. Just imagine if a woman beat her husband to death this morning, and she's arrested by police, and the prosecution compiles a file with police in a rush, and they finish everything. And today, the same morning, that lady is produced before court, and the court releases her to go back home. Sometimes we have the public sentiments. Sometimes we have this court that sits under the trees and starts looking at what the court has done. Is it fair? Is it just? So when the judicial officer is going to grant you bail, there are so many factors that we look at, very many. Sometimes it is for only your own good that we don't grant you bail, because there are so many people who have been granted bail and they go back on their way and they are lynched and killed. There are very many of them. There are so many cases that happen out there in the public, and investigations are still going on, and a judicial officer will feel and think it is not fair that this person be released to go back home on the first day. There are so many cases that happen out there in the world, and there is so much confusion to the extent that you need to get this suspected person out of saturation for some time for the dust to settle, and then they can be able to go back home. That is why I'm telling you they give us powers to do it, but we are also cautioned to use those powers in a professional way. If I have, that is why you see, if I have not granted you bail, I should be able to explain to you the reasons why I have not granted bail. To the extent that if those circumstances change, you can still come back and reapply for bail. I can use an example. If, for instance, you are charged with an offense, a very serious offense, and then you bring your children as your sureties, children who are 18 years, 19, and then you are a person of about 50 years. In my wisdom, I can think as a judicial officer that these children will not be able to compel you to come back and stand trial. Because indeed the duty of a surety is to be able to compel an accused person to come back to court. So how will a child have powers over their mother or their father to ask them to come back to court? So I may not grant you bail based on that, and if it is a reason I have given you, and then on the next hearing you have other sureties who are maybe your relatives or your neighbors or friends, and I may find them fit at that stage, so you can resubmit your application and apply afresh. I can tell you there's a lot of confusion out there in the world. It is the reason that you're seeing judiciary has put a lot of energy and efforts to sensitize people about bail. It is one of the hottest spots that we have in our institution. It is one of the spots where we have been bashed, where we have been abused, where corruption has been alleged to the highest
extent. I love that last word, corruption to the highest.
Where corruption has been alleged. So when we come out to educate the world about bail proceedings and processes, we are very intentional. We want them to follow the processes. And even when you have not understood, you can still go back to the judicial officer and ask, Your Worship, you made this statement when we were in court. You said I have not been granted bail because of reasons A, B, C, D, and D. Now my sureties have come. In the morning you did not grant me bail because my sureties were not there. Now they have come. Sometimes you have a situation where a person appears in court in the morning and they are not granted bail because they don't have sureties, but in the afternoon their sureties show up at court. My advice to you is that put your application in writing instantly because you are still at court. Put your application in writing, attach the documents of the sureties, let that application go before the judicial officer. Then the judicial officer will see whether they can grant you bail at that stage or not, because in the morning, the circumstances that were prevailing have changed in the afternoon. So we want our people to understand all those things. There is no judicial officer who benefits by sending people on remand. They are not there. Even when people are on remand or coming from their homes and are able to stand trial, as a judicial officer, I don't have anything to lose. What I have to look out for is to balance the interests of both the complainant and the accused person. To the extent that if you don't qualify for you to be granted bail, I should be able to explain to you. But also if you qualify, as long as the complainant, also personally, I feel if a bail application is handled in presence of a complainant, there wouldn't be a reason because they will understand why the court has granted bail or denied bail. But even if they are not present, remember the state attorney who is in court is representing the interests of the complainant. So we usually use them to let the complainant know why bail has been granted or not granted. So I want to call out the public out there, whether you come to court as an accused person or as a complainant, and bail has been granted or denied and reasons given, be interested to know the reasons why bail has been granted. Be interested to know why bail has not been granted, and watch out to see if those circumstances have changed. Then you can resubmit your application before court, and the judicial officer should be able to entertain it. That is now at the chief magistrate's level, or let me say, okay, at the lower court level.
Well, just allow me go for a short break, and when I return, I'm going to be joined by a name very popular in the media, and that is her worship, Gladys Kamasanyu. She'll be joining us. Let's go for a very short break.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
Step into a world of excellence, comfort and pride with Royal Foam Furniture, crafted to perfection right here in Uganda. We bring you state-of-the-art living room furniture and bedding products at affordable prices. Our wide variety of mattresses include orthopedic, pillow top, spring mattresses suitable for institutions like hotels, and many others for home comfort. With every piece telling a story of royal excellence, our products are built with the highest quality materials made to last. Experience royalty with Royal Foam Furniture, proudly made in Uganda, so buy Uganda and build Uganda. Visit our showrooms at Ginger Road, Chambogo Junction, Bukoto Chisasi Road, and on Victoria Mall, Entebbe, on the first floor.
Africa is rising. A continent rich in potential, powered by a new generation of visionaries. From cutting-edge technologies to transformative industries, Africa is shaping its own future. Bold, sustainable, and value-driven. Inspire Africa Group welcomes you to the first Africa Business Forum, which will be held at Africa Coffee Park under the theme Innovation, Industrialization, and Value Addition on the 23rd of May 2025. The chief guest will be His Excellency Yoweri Kaguta Museveni, President of Uganda, and His Excellency Dr. Samoei William Ruto, President of Kenya. Come, engage with the key policymakers, forge strategic partnerships, and unlock new markets. Join us as we reshape Africa's economic future.
Oyo ye Diplock Sega wanga chaguze myaka namu esatu nga 23 May ku National Theatre. A lifetime of melody concert, 43 years of Diplock Segawa performing in Kampala for the first time in a long time. Enyimbo boba dowuli ampulire kati jangu Diplock Segawa hazikuyimbire. Tickets eya gold ya mitwalo 15 ate VIP ya mitwalo 30. Booking a ticket yo ku noti 775 oba ku www.carrytickets.com oba ku National Theatre. Ono ye Diplock Segawa. Abiri musatu May 2025 ku National Theatre, celebrating 43 years of Diplock Segawa. Bitutusibwako Charism, UNCC, UNMF, Statewide Insurance Company, UCC, Riz Medical Center, Donjo Fashions, Hot, Q Vibes, Nekari Tickets.
Uganda Development Forum, in partnership with Uganda Broadcasting Corporation, is organizing a 2-day Musevenomics Conference on the 29th and 30th of May 2025. The conference is dedicated to exploring Uganda's revolutionary economic model under the theme, Sustaining Musevenomics, hence navigating Uganda's economic future in a disrupted world. His Excellency, the President of the Republic of Uganda, General Yoweri Kaguta Museveni, and the chairman of Uganda Development Forum, General Salem Salih, will lead a team of distinguished speakers in economics and development. The Musevenomics Conference 2025 is sponsored by Uganda Development Forum in partnership with Uganda Broadcasting Corporation, Uganda Development Corporation, Parish Development Model, and Operation Wealth Creation.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
Welcome back from that break, and thank you for keeping it on UBC TV. I have Her Worship Gladys Kamasanyu with me. You're most welcome to the show.
Thank you.
And when you came in, yes, with Her Worship Nantes, we had looked at a number of things, most of what bail is. We had looked at bail application, and I want to take you at that. Now, how does one apply for bail? Because you talked about, I think that was either in the lower courts, where I can raise my hand and say, well, I need a bail. But then again, she talks of a process of applying. So how do I go over that?
Okay. So in the lower courts, like you said, just by raising your hand, whether you can speak by word of mouth or you can express yourself by action, and we have translators who are able to make us understand what you're saying. In whichever language, sign or actual words, you just raise your hand and tell the judicial officer that you need to apply for bail. Because it is your right to apply for it. So it is by oral application. You don't need to put it in writing, you don't need to file it in court, but by raising your hand, ask for bail, put your grounds why you want to convince court to grant you bail, and then court will hear the application there and then when it is possible, or stand over a matter to perhaps make the other party that represents the state to prepare for your application, or give us short adjournment to hear your application, and come that time, you still will come by your words, by sign, as court. Court will listen to you, will listen to the other party, who is the state prosecutor, and then determine whether or not you'll be granted bail. And as she said, when bail is not granted, reasons for such a denial should be given. But also when it is granted, there should be reasons given by court for you and the prosecutor to know why bail has been granted to you. So that is in the lower court. It's by oral application. Now in the High Court, another courts, the Court of Appeal and Supreme Court, it's in writing by way of an application, which is a notice of motion supported by an affidavit, where you are stating why you want to be granted bail, laying your grounds, putting documentation like your nation ID, your passport, to basically identify yourself, supporting documents to show that you really need to be granted bail. And of course, in both courts, high and lower courts, you should be having some people that you have brought to guarantee that you will come back to court once released, to go and keep answering the charges or charge from home to court, as opposed to answering the charge from prison. Yes, so those are the two different applications.
Your Worship, Nat, is there anything you want to supplement?
What I can supplement still is, like I told you, bail is done when you have been produced in court at the lower court. But now there are instances where you have been convicted of an offense and then you appeal against the conviction. So you're coming from the lower court and going to the High Court. So you also can still apply for bail pending the hearing of the appeal. People don't know all those things, and that's why we want to be emphatic when we come here. So it doesn't mean because a lower court has sentenced and convicted you, you cannot apply for bail in the High Court. You can apply for bail in the High Court pending the hearing of your appeal, but you should be able to raise those grounds in your application to show that I've lodged an appeal, and the grounds of my appeal are A, B, C, D, and D, and for that reason, I feel I should be granted bail to go back home and stand trial while coming from home. But also there's another instance where a court, in a lower court, an application has been heard, and you find that during the process of the application, some omission has been done that is very, very fatal. You're not appealing against the decision of a judicial officer, but you feel like an error has happened on the record that has to be reviewed by a higher court. So even pending revision, a criminal revision in a higher court, you can still apply for bail. So that means there are 3 instances when a person can apply for bail. When you're freshly charged before court, when you have been convicted, but you want to appeal, or you have appealed against that conviction, and also when a revision is pending before the higher court, or even when you have been taken to the High Court and the matter is a matter that is handled by the High Court, but you're still appearing in the lower court, so you can apply for bail, which is the same instance like you're produced in the lower court instantly. I don't know if that is clear. When you go to the High Court, you can just normally apply like you're applying in the lower court. When you appear before the lower court and you are sentenced and given a custodial sentence or whatever it is, usually it is a custodial sentence, you are appealing against the conviction and sentence, you apply for bail. There's a matter handled in the lower court, and you feel that there's an omission or something that has happened, an error has happened on the record that you need the higher court to review, you can apply for bail pending the revision. Yes.
Well, very clearly explained. Now, Your Worship Gladys, what is it that I must have to apply for bail?
Okay, so first and foremost, you must make the application. The Constitution guarantees you the right to apply, so you should be able to apply. If it is in the lower court, like I said, you have raised your hand, you have put it before a court to say, please grant me bail. If it's in the other courts, you have filed the application. And then, so, you should be able to have supporting documentation, for example, as I said, identification documents to show who you are you Ugandan, you're not Ugandan, where are you based, and I mean introductory letter from the area local chairperson where you live to say that, oh, this is a resident of my area, he's been here for so many years, he's law abiding, we know him. Because when time comes and we need you, we will likely use that letter to trace for you, maybe by your place of residence. So we will need to go tracing you like that. And then you should also be having people, these are your sureties, your relatives, people who know you, that can guarantee that when you're released, they will support court to trace for you. They can compel you if, for example, there's need to use force. And we have seen it happen, like someone is released on bail, they go home and say anything to me, you'll see. So they can drag you back and say, the person is here, actually we are no longer interested in being his surety because of A, B, C, D. So you have those. But also, like proof of, I talked about proof of your work, your residence, show that you are out there, you are doing something. We can as well look for you from where you are based, maybe work or that. So we are able to come to you. Your sureties should be having letters introducing them to court. So we also know that in the event we have to look for these sureties, we can trace them through this address. Yes, but also the age of the sureties. Not every person will come stand surety for someone who has been, yes.
Age, well, that is something that you should listen.
Yeah, so that's why you can't bring a baby. Oh, this is my son. I have been charged and he knows me so much. He's a baby, he's 10 years old, he's 12. He can come and tell you where I will be. So the age of the person, that age of responsibility, at least from 18, depending again on the nature of the offense. Yeah, a person who can ably prevail over you, can aid court to be able to come back to court. Yes.
Now I go to a very interesting part. I know many Ugandans are willing to listen to. Among the things that her worship Nanteza and her worship Kamasanyu, we've not discussed money. Now let's go to that point, and I want to begin with your worship Nanteza. Now when we talk about money, first and foremost, when does money come in? Or sometimes I hear even land titles, but when do those extras come in?
Thank you very much. Like I told you, the accused person presents their application before court. The court looks at the evidence that has been placed before it and makes orders. A judicial officer will either grant you a non-cash bail or a cash bail, depending on the circumstances surrounding the commission of the offense. They will determine the amount to ask you to pay, still depending on the nature of the offense and the circumstances surrounding the commission of the offense. But also they will depend on a lot of other factors that they may not tell you. I'll tell you, you can't go to a place like, I will use Parish, I worked in Parish, and then you start granting cash bails of 5 million. That means everyone is going to remain in custody. Even 500 sometimes seemed too much for them to pay. And to the extent that even when I was there as a chief magistrate, I would always try my best to grant non-cash bails, but I would make sure that other conditions like making sure you produce substantial sureties was a sure deal for me. I would make sure you produce someone maybe who works with the government, and then I would know if you're lost, we can go to this hospital or maybe this school, and we pick this teacher to find out where you are or where you have disappeared to. So court will grant you a non-cash bail or a cash bail depending on the circumstances of the offense. People usually think we use it because we want to punish them. No, it is the nature of the offense, because still, like I told in the beginning, when you grant bail, sometimes there's a lot of public outcry. When you don't grant, sometimes there's still a lot of public outcry. So for us as arbiters of justice, we are there to see how to balance the scale. How do we grant bail in this circumstance? Okay, someone has applied, they have murdered their husband or their wives. How do I make this bail look like it is not just a handshake and you're going back home with an offense that you have committed at the back of your mind? Of course, we know that everyone who is charged before court is presumed innocent until found guilty. But there are those circumstances that you look at even from the beginning of an offense and you're like, no, I think this person should not just go back home. The public out there will not see justice. When we are administering justice, the maxim is that justice should be seen to be done. But we are now shifting our way. It should be seen and felt to be done. how am I going to do justice? And a person out there will know that indeed I feel justice has been done to me. A person has murdered your relative, you have found them with them in cold blood, all evidence points to the fact that they have murdered them, and then they come to court. Even when there is that presumption of innocence, the court should act in such a way that makes the public out there feel and think and see that justice has been done. People only look at bail when they have their persons charged before court. They ever look at the other side of the coin when you come as a complainant in court. Because when you come as a complainant, you feel very aggrieved to find court just granting bail to everyone who comes on and everyone who comes. If I was a judicial officer process at Buganda Road and they arraigned like 10 people before me today, I released them. Another 10 tomorrow, I released them. Eventually the public will feel like there's no justice that has been done, because indeed there are those people that we feel should be out of the community, for the community to be able to thrive, for the community to be able to stay in peace, and for the people to be able to carry on with their production and growth at whatever extent that they are. So when a judicial officer feels and thinks they should grant you a cash bail, they should be able to pronounce it in court and in open court. These are some of the hotspots that we have. Someone comes to court, they apply, they have intentions of applying for bail, but even before they have lodged the application before the judicial officer, they are giving someone money in the corridor to help them get bail. That money you're giving to people is, you're giving them pocket money to look after their children. When you come to court, my advice is that go to court, sit and wait for the judicial officer to pronounce themselves on either a cash bail or a non-cash bail. When they pronounce a non-cash bail...
And briefly, what is a non-cash bail and what is a cash bail?
That's where I was going. A non-cash bail means they have allowed you to go back home on a condition that, if for instance, if I say a non-cash bail of 1 million, you will not pay the money in court on that day. But when you go back home and you fail to honor the terms that the court has set for you, then you'll be compelled to pay that money. You pay it at a later time when you have breached the rules that the court has set for you. When I say cash bail, it is supposed to be paid on that day before your release. So non-cash is paid later when you have absconded. But still, even when it is non-cash and you don't abscond, you will not pay that money. So what I would like to advise the public to do is, when you get an opportunity and a judicial officer has granted you a non-cash bail, please comply with the terms. If for any reasons you're not able to come to court, someone can be sick, you may sleep very well in the evening and you wake up in the morning feeling very unhealthy, feeling very unwell, let your sureties come to court on that day and inform the judicial officer the reasons as to why you have failed to come to court. They will not ask you to pay that money. They will just give you another date and they will make it convenient in such a way that, for instance, if this morning I learned that the accused person who is supposed to appear before me got a stroke, I cannot expect them to come to court next week. People forget that as we administer justice, we don't lose this human face. We are human beings in nature. We are your children, we are your wives, we are your mothers. We don't dispense justice in a vacuum. Let people learn to communicate to judicial officers while they are in court. If a judicial officer has told you come back next week, and for instance you come from very far and use like 50,000 to come back to court, you can still raise your hand and tell him, Your Worship, you are expecting me to come back next week, but even the transport I used to take for coming to court, I borrowed it. Please allow me like a month to look for money and come back to court. That if we reach a level where we are able to communicate with our customers, because court is like a market. People who come to us are like our customers. They have come to buy our service. They have come to utilize our service. We should not be seen to undermine them. We should not be seen to do things that don't favor them to go on and prosper with their lives. People should be able to communicate to us or with us. That even means when a judicial officer grants a cash bail that you feel or think is very exorbitant, you can still have engagements with them through writing, through your lawyer. If they fail to address it at that level, you can appeal against the amount of money that has been asked to be paid. Because if I go to Chanamkaka, deep in the village, and ask for to pay 10 million as a way of releasing them to go back home, surely even on the face of it, it looks very, very unfair. Because you'll find that someone can take like 10 years before they can access 10 millions. There are people who can come to court and they will tell you, Mlamzi, you see me here, I've never touched 500,000 shillings in cash. Or if I have touched it, it is not my money. So if a judicial officer went to such a place and granted exorbitant amounts of money in form of cash bails, it is not acceptable. People should understand that the judiciary is a people-centered institution that wants to give services to people in a way that is human or in a humanly way. So when you encounter something that you find is inhuman, that's why you have those so many levels of appeal where you can go and something will be addressed.
Well, at that level, allow me to say, indeed, the first time I met these two wonderful ladies I have, in fact, I remember before going on set telling her worship Nanteza that these are unique breeds of the judiciary. That when she came in, the talk, I almost asked her, are you the one? So, and when it comes to her worship Gladys Kamasanyu, I think there has been that fear for the judiciary. You know, knowing it's more or less a sanctuary, a temple of justice. There is that fear that the public has. I one time was a court reporter for a very short time. But I want to tell you, even some of us that journalists, you know, the moment you enter court, like you feel something has poured on you. Oh. The moment you see a magistrate, there is that feeling. Today morning I saw one, I was doing my things and I was waiting for another one. But then she told me, I'm the one you're waiting for. And if we can break that, because I think why people fear these things, but also the people who exploit others in the judicial chain. No, someone even takes you, you're talking about Kamasanyu. Are you in your normal senses? Are you for sure that you want to address an issue with her? Do you think it is even, that is unthinkable? So I think as we try to break and let the public know, even the judicial officers themselves must be willing to break that cycle. Must confess the ones I've had today are very unique and a rare breed in my career as a journalist. The ones I'm having today. And I've told her already, even as if you're hosting a judge, my friend, there is that fear carried throughout. You see it at the judiciary, you see it everywhere. But thank God, at least we are getting somewhere. It's work in progress, and we hope we shall arrive there. Now,
can I finish the cash bail?
Please.
So when a judicial officer pronounces that you're going to pay a cash bail, listen to the amount that they have told you to pay, go to the cashier for assessment. That money should be paid in the bank. Cash bail money is not still paid at court. It is paid in the bank. It's paid to URA actually. Any bank, either Stanbic or Centenary, as long as it goes to URA. When you go to the bank, they will give you a receipt. You come back with that receipt that has been issued to you in the bank, present it to the cashier. The cashier will give you a receipt for judiciary, a receipt for court. So that means now you have two receipts, one for the bank and one for the court. Then the cashier will ask you to take those documents, or they will take them to the file where the judicial officer ordered that you're going to pay a cash bail, and then the judicial officer will sign on your bail bond paper. That paper which allows you to go back home and stand trial while you're coming from home. We are being very emphatic about these processes because people sometimes do the last things first and they do the first things last. Wait until the pronouncement for cash bail has been done. Know the amount that you're supposed to pay. Take the money yourself to the bank to pay. No one should be helping you to pay that money in the bank, because someone will tell you the judicial officer said 5 million, but I think in the bank they need bank charges of 500,000. They will be cheating you. Go to the bank, or maybe go to a mobile money agent, make the payment, and then come back with a receipt. The process should seem as easy and smooth as it is said here. People make things complex because they come to court when they are very terrified. I want to use this opportunity to tell you that you should not fear us. You should just respect a place you have gone to. You see me here, I'm a judicial officer. I have a daughter in primary 4. When I go to school, I have gone to the class teacher of my daughter. I will be as humble as possible. I will listen to them. They will advise me on even on things that I think are not practical. They will tell me now, when his daughter comes back in the evening, help her to do homework. When deep inside me, I know I come back when I'm already tired. I will not do that. People should just understand that when you come to court, you're only mandated to respect authority but not fear. When you have a concern, raise your hand. The judicial officer should be able to listen to you.
Well, time is flying very fast, but I'm enjoying every bit. Now I want to bring in Her Worship Gladys Kamasanyu. Is this money refundable? When and how?
Okay, so when bail is granted and you've been ordered to pay cash, as security for your return. Remember, grant of bail is not the end of the case, and sometimes our people misinterpret it. So at times we grant bail, and then the complainants, those who brought the cases to court, say, you see, now the case is dead, they have released him to go, they don't even care, that one won't be heard. And at times some of them actually think the case has been ruined just by grant of bail. They don't want to come back to court because they're seeing the person will be coming from home. Yes, so when money is deposited as a condition for grant of bail, that is your money. The condition is pay that amount in the bank, like Hawaship has said. You have your receipt that the court has issued to you. That receipt comes from the cash office. It has the case number, it has the name of the accused person, it has a date when bail is granted, it has an amount that you have deposited in the bank. That is your money. So your duty is to keep coming back to court from the time you're granted bail until the case ends. When it ends, you have a right to claim for refund of your money. And the process is very, very simple nowadays. Just by coming to court, we give you an application to fill. That's a simple document for you to fill, give us a few particulars, but also, please avail us, come back with your general receipt, which is original. The one we gave you when you are granted bail, come back with it. We will attach it on that simple application. The court that issued you bail, that granted you bail, will prepare a document addressed to the Permanent Secretary of the Judiciary to confirm that you were tried before a court, the case ended, so much money was deposited by you as a condition for grant of bail, and therefore it be refunded to you. The refund process is that very simple, so you leave those documents with us to send to the High Court where the Permanent Secretary sits, and then the money will either be put to your account if you have put your account number as where you want the money to be refunded, or if you have put your mobile number as where you want the money to be paid, it will surely be paid to you. And that's why I want to emphasize that's your money. When we give you a receipt, that original payment slip, please keep it, bring it back to us. But also, it is possible that you may misplace, lose the receipt. We have seen all those cases. Somebody comes from far away, maybe their bag was stolen, and this, we usually lose property and all that in many ways. So you have lost your receipt on which you deposited the bail money. Please come to us. Court has a record on the court file which shows that indeed you paid the money. We have a copy of that same receipt. So you will have to sign a simple document to show that it is you narrating to us how you lost the money. So basically to confirm that you lost the money, how you lost the receipt, yes. Confirming to us that you lost the receipt, like incidents that led to your loss of the receipt. And then we will make a copy of the receipt, of the general receipt we have on the file, attach it, still attach the same documents that court has to attach, sign them and send them to the Permanent Secretary to have the refund done. So yes.
Now let's also look at the sureties. And when you talked about when the case is done,
yes,
you see, we need to be very clear. The case is done as in, I was sentenced, I've served my sentence. What do we mean by when the case is done, you can come and get the refund?
The case is completed.
Yes, or the case is completed.
Remember, the condition for deposit of the money was for you to keep coming back. You have come back. You didn't jump bail. You were obedient to that term which court set for you. So when the case has come to an end, court has pronounced itself like a final verdict, that final decision of court which brings the case to an end. Either the case is dismissed, for example, where no witnesses have been brought to court, and after a long time of waiting, court says, okay, this matter is dismissed for want of prosecution, because those who filed it before court have not followed it, have not come to testify. It is dismissed. You're discharged. Don't come back to court. You come and claim. It is hard. You were acquitted. Come back and claim for your refund. It is hard. You're convicted, but you kept coming back the whole time, because that was their condition. Come and claim your money.
I'm convicted, and I'm now in Duzira. I'm in Chitalia.
Whenever you're able to come back, because now you perhaps you may have to first serve
a sentence.
Yes, sadly.
What an interesting discussion, and I love the fact that judiciary is now coming out to explain this, and these are officials of the judiciary explaining this, because most of the times the challenges we've gotten are people within corridors of the judiciary telling the public. I don't know a court I've gone through and I've not seen those unofficial staff of the judiciary. There's always someone who will tell you they know Her Worship Kamasanyu more. There's someone who will tell you, I know Her Worship Nanteza more. There's always someone there, and they give the wrong information, usually. But I'm happy that now the judiciary is out there and you're explaining these people these things. Now, time is flying very fast, but I'll just give each of you 3 minutes for your parting shot, beginning with Her Worship Nanteza.
Thank you very much. I want to acknowledge the fact that there's a lot of public outcry there when it comes to bail refunds. As an institution, we have gotten the feedback, and we are doing our best to make sure that we simplify it even further. I happen to sit on senior management, and there's no time we don't discuss issues to do with bail refund, because here we are, we're stuck with people's money. We want to give it to them, but somehow they're not getting it in time. Somehow they're not able to get it without hassling a lot. We are working behind the clock to see that we make the process simpler and easier. But also, when you hear people saying they don't claim their money, or they don't get their money, some of them have actually not lodged any claims. They have not applied for it.
Someone says, I've been acquitted, now I go back to court claiming money.
That is what I was going to tell you.
I've
some people fear to
I
come
take
back
myself
to
back
court.
to Kamasanyu.
Some people fear to come back to court. They think they are going to be rearrested. It is not possible. Remember, in the first place, it is not the court that arrested you. It is the police and the Director of Public Prosecutions, and then they brought you to court. As a judicial officer, I am not an arresting officer. Actually, we don't even sanction arrests inside court premises. We don't. We don't sanction them in any way. We condemn them to the highest terms. There is no way you can come to court to apply for your refund and I will be arresting you. Let people know. That's how they cheat them. That's how they lie to them. And whether you know English or you don't know, you can still be able to communicate with a judicial officer. Just walk to their chambers and tell them, Your Worship, I had a matter here. I was convicted. I have served 5 years. This is my documentation. I applied for bail. I was granted bail. This is my receipt. I want to process my refund. You know, money is money, and documents they don't get rotten in any way. Anytime you want your money, you can come and apply for it. But also, as an institution, we are having a challenge. Remember, the person who is granted bail at that time of granting is in custody. So in most cases, they're not the ones who pay the money. It is the surety that pays the money in the bank, but is paid in the names of an accused person. What I want to clarify using this forum that we have had this morning is, it is the accused who has to apply for that money. So that is where the problem also sometimes is. Remember, for you, you are my brother, you are in custody, I am your sister. I am getting my money and paying for you, but putting the receipt in your names. So sometimes we have instances where, now when you come out, you want to take that money as yours. Remember, it is me who paid it. And now for us in court, because it is you who is in our documentation and who was presented before us, we want you to be the one to apply for the money. So there are those unresolved issues, sometimes which are not done by, which are not on the side of the judiciary, that the public out there does not understand. We have many people who have not come to apply for their bail refund. Recently, we were in Parliament, they bashed us, it was all over social media. I was part of that team. And we kept explaining to them, Honorable Minister, MPs, there are even some that we know and we see everywhere moving, but when we know we have their money, but they have not applied for it. So we want to call upon the public, if you have your money, paid in whatever court. As long as you have a receipt for it, go back to that same court and claim your money. There are instances where a court, like in 2020, was a grade 1 court, but now it is a chief magistrate's court. It has been upgraded. It is still the same court. So don't fear to go back saying, New Masaka that time was a grade 1, now it is a chief magistrate's court, I cannot claim my money. As long as you have a receipt from the judiciary, you can apply for money, and we should be able to give it back to you, or even give you reasons why we don't give you back your money. But also I want to encourage them, as you apply for a refund, put your telephone contact, put your account number, put a number that is registered in your names. Because if you put from your mobile money number on the application that is in the name of a third party, most likely we shall not pay that money. But also they should know that we are working behind the clock to make sure that we streamline this process. It is one of the biggest sale funds in the house as I speak now. We talk about it on a daily, but we don't just talk about it only. We are trying to streamline and make sure how is it going to be easiest for a person who has come to court and paid their money, be able to get it in time and be able to go and use it. Because indeed we don't use that money as judiciary. It is heaped on the bank account, it is there, and even the owners cannot access it easily. So what do? Let us bring our heads together, you and us. Let us get positive feedback. When you get your money in time, please be out there and let people know that the money is given. You know, it is unfortunate when someone who has not gotten theirs is then making loudest noise. It is okay because they are crying out there, they need their money. But there are also those ones who have gotten their money within 1 day or 2 days, and they have it on their account.
Well, thank you so much, your worship, Nanteza. Now let me move to Gladys as we get out of here.
So I want to start it from where you stopped. It is so true that many of our court premises, there are people that have planted themselves around court, especially in Kampala courts and other towns. So you certainly will find somebody in the corner who trying to dress like us, trying to be smart, speaking English, trying to put you in a corner to say, you know, if you want her to grant bail, this is what you have to do, give this, give that. Please avoid all that. As judiciary, we have tried as much as possible to make our staff be identifiable. They wear, most of our courts, our staff will be wearing our tag, our ID, and you can see. But also, they'll be seated in the offices that we have. We have receptions at every court, that desk where you come first. Please go there. Don't fear to ask. Use any language you want to speak, whatever language you understand. Go there and explain to them why you are at court, what you want, and they'll be able to call whoever it is supposed to be working on whatever you want to help you. Do not be called into corners by people, those buffet. They have actually done it to people, and that has continued to tarnish the name of the judiciary. Honestly, Ugandans should avoid shortcuts. Go to the right office. Our doors are open. We are keeping all over the country. We are keeping our doors open. The person heading the court, their door is open. You have a right to walk there and ask that you want to see that chief magistrate come assign you. You want to see that registrar. You want to see that person that is supposed to address your problem and talk to them about what you want. They will guide you. But also in court, this is another dilemma. I don't know what happens. Today we have people coming to court and thinking that for their bail applications to be heard, they should be having lawyers. They have gone and sold everything to pay to a lawyer to come to court, to stand in court, to apply, to orally talk, to apply for bail. And that is all they have been paid to do. Now that is wrong. Ugandans, don't be misled. You can't do this for yourself. If you can't afford a lawyer, and we will listen. It's not true that whoever has a lawyer wins a case. And of course, it's not true that whoever has a lawyer will be granted bail because it's a lawyer who has applied for bail. It may or may not be granted, like we have already explained. Please, if you can't afford a lawyer, and it's not one of those cases where you must have a lawyer, most of our cases that we are handling, the ones we are charged with, you don't need a lawyer. Please walk to court, put up your hand, talk in a language that you understand. We are there, we will listen to you, we will afford you an interpreter so we can communicate. And please, after the end of the case, remember to come back and claim for your money where bail has been paid in cash. Or if you have been asked to deposit another form of security as property, we have had titles in courts and other forms of security that you people do not come back to claim. Please come back, claim for your property because the case has come to an end. Go live in peace. Know your right. Don't get scared of human beings. She has said, we are human beings like you. We are mothers, we are fathers, we are everything like you. We listen and do what you want us to do for you.
Well, thank you so much, Her Worship Lady, that is Gladys Kamasanyu, and also Her Worship Zulaika Nandeza. I've enjoyed myself, I must say, learning more regarding the judiciary, but we've been focusing on bail, process, its application, and the refund. Go pick your money. It is your money, and you have the right to get that money. But also, don't be deceived. Let's break the chain. Let's break the chain. Let's break the fear. Try and keep trying. Avoid middlemen. So with that, I believe the judiciary will serve us, will understand how it works, and justice will be served. She said now it's not only being, justice will be felt, that is really being given. Have the best of your day. May the good Lord bless you. See you tomorrow.
Live from UBC Studios in Kampala, this is Good Morning Uganda Extra.
This May 24th is the grand finale of the Pearl of Africa Tourism Expo 2025. Festival Day at Speed Resort Munyonyo. Experience a vibrant mix of music, dance, fashion, art, a fun-filled kids section, and an epic boat regatta on Lake Victoria. Live on stage, Luzri, Winnie Nwaji, Abeka Band, Otim Alpha, Sunabed, Shilagashumba, Salvador, Alideki